Doctor. My name is KH'NG and my metric number is 274056. The part that I'm going to present is the introduction. According to Article 36, subsection 1 of the Statute of the International Court of Justice, the phrase all cases which the parties refer to it carries the meaning of the court only has the discretion to exercise its jurisdiction over the case when the parties intend to refer to it. The term parties denote that every party involved in the dispute must give their consent to refer to the court. Hence, the court's jurisdiction is just voluntary but not compulsory. Moving on, the parties' consent is crucial for the court to have the jurisdiction to deal with the dispute. Consent can be given by the parties expressly and impliedly. Consent of the parties can be inferred as the parties' consent is not limited to a particular form, and the court is allowed to infer the consent via the parties' conduct. According to the case of Corfu Channel preliminary objection, the unilateral applications of the applicant state attached with letters from another party enable the court to infer consent as these evidences presented their acceptance of the court's jurisdiction. Not only that, an agreement can be constituted by meeting minutes between foreign ministers. In light of Qatar and Bahrain, the issue arises when the foreign ministers have signed a meeting minutes, so the court recognized these meeting minutes as an agreement under international law. Furthermore, consent of a state that the court will recognize may be expressed in four ways, such as by special agreement, by forum prorogatum, by a compromissory clause in a treaty, or by accepting compulsory jurisdiction under Article 36, subsection 2 of the statute. That is all from me. I will now pass the floor to the next presenter.
Good morning to Sir Nasran and my fellow friends. My name is Inka Yao and my metric number is 272-07. Today I will present the part of jurisdiction of ICJ by a special agreement. In general, the classic method by which the parties refer a case to the court is by a special agreement, as known as compromise. This is an agreement whereby two or more states agree to refer a particular and defined matters to the court for a decision. According to Article 36, paragraph 1 of the Statute of ICJ, I quote, "The jurisdiction of the court comprises all cases which the parties refer to it, and all matters specially provided for in the Charter of the United Nations or in treaties and conventions in force." In other words, when states decide to refer an existing dispute to the court, they draft the terms of what is called a special agreement, in which the subject matter of the dispute and the identity of the parties are indicated. The special agreement is then notified to the court, and the jurisdiction of the court will be limited to what has been agreed by the parties in the special agreement. In the Agency Continental Shelf case, Greece argued that Turkey had consented to submit the dispute to the ICJ by a joint communique following a meeting between the two prime ministers in Brussels in May 1975. But the court said that there was no special forum for a special agreement to exist if there is no immediate commitment. In Malaysia, the recent examples are special agreements between Indonesia and Malaysia relating to the case concerning sovereignty over Pulau Ligitan and Pulau Simpadan, and also the special agreement between Malaysia and Singapore in respect of the case concerning sovereignty over Pendra Bancha / Pulau Batu Putih. So that's all from me for the part of the jurisdiction of ICJ by a special agreement. I will pass the floor to the next presenter. Thank you.
Good day, sir. I'm YUEN with matrix number 273410. Now I would like to continue with our group presentations with regards to the other two methods in which a state may express its concerns, granting the court the competence to settle disputes, namely concerns given by a compromissory clause in the treaties, and the concerns by forum prorogatum. First and foremost, it should be taken note that there are a lot of treaties and conventions in force which include a jurisdictional clause. By insertions of such compromissory clause, consent is said to be given by the contracting parties to the treaties, whereby the state may refer the dispute to the International Court of Justice through a written application instituting proceedings if the other contracting parties disagree over its applications or interpretations. It shall be emphasized that such way of expressing the concerns does not take into account the nature of the treaties, in which the treaties concerned may either be a treatise governing some other topic and containing a compromissory clause or a general treatise for a peaceful settlement of disputes. This legal doctrine can be clearly illustrated through the decided case of Tehran Hottage case, in which the court has been granted the jurisdictional right to hear the disputes based on the protocol to the Multilateral Vienna Convention on Diplomatic Relationship 1961, as well as the bilateral treaties of amity, economics, and consular rights between two parties. Moving on to the concern through forum prorogatum. This doctrine has permitted an informal way for a state to express its concerns to the court jurisdictions, whereby the state may subsequently accept the jurisdictions of the International Court of Justice to enable the court to adjudicate a dispute, even if the state have not recognized the jurisdictions of the court at the beginning of the time when applications instituting a proceeding has been filed against it. In this respect, it is important to highlight that there is absence of requirements which requires the parties to express its concerns in any particular form. With that being said, the concern of the party can either be done explicitly or through any implied manners. This legal principle can be strongly supported in the landmark case of Corfu China case, where the court held that the Albania has signified its concerns to the jurisdiction through the letter sent to the court registrar, despite the fact that the United Kingdom had initiated the proceedings by unilateral application. That's all from me. Thank you.
Hi, my name is Loishin and my metric number is 271620, and my part will be discussing on acceptance of compulsory jurisdictions under Article 36, Paragraph 2 of the Statute. So we know that in national legal system, a court jurisdiction is applicable based on the consent of the disputed party. So the common issue often arising in international plan is whether ICJ has jurisdictions over the state by using the principle of compulsory jurisdictions. However, it can be said that ICJ cannot apply the compulsory jurisdictions to bind all the states to follow the jurisdictions of the court, because it is an optional clause under Article 36, Paragraph 2 of the Statute. Compulsory jurisdiction is only compulsory to those states which consented to be bound by, and those states which is not consented to be bound by is not necessary to be bound under the compulsory jurisdictions. It can be shown in the case of Nicaragua case, where the case provided that states are absolutely free to declare their acceptance of the court compulsory jurisdiction with its condition. So we know that in general, a state only can be bound by its compulsory jurisdictions under international law if the state made declaration under Article 36, Paragraph 2 of the Statute. So this can be linked to the principle of reciprocity, whereby there are two conditions to be fulfilled in order to be bound by its compulsory jurisdictions. First, both states of the disputed state must have made declarations under Article 36 of Paragraph 2 of the Statute, whereby the court can exercise its jurisdictions over the state that has consented to it. Secondly, the ICJ only can exercise its jurisdictions to the extent to which the declarations of two states coincides. So basically, whenever a dispute comes within the scope of the consent, the state must submit to the court jurisdictions. That legal requirement is at the heart of the term compulsory. So in conclusion, a state only can be bound by compulsory jurisdiction if consented to its jurisdictions. Under Article 36 of Paragraph 2, it is an optional clause. That's all from our group. Thank you.